Everyone, thank you for joining us. This is Mitch Tanenbaum. Dan Nelson, partner at Armstrong Teasdale, is on the call with us, and this morning we're going to talk about the new Colorado privacy legislation that goes into effect on September 1st. This legislation is part of a nationwide trend to go off and either implement in a few states that didn't have privacy laws or tighten privacy legislation in existing laws. In the case of Colorado, there are some features of this law that impact every business, every company doing business in Colorado, and we're going to talk about that. So thank you for spending time with us this morning. Feel free to put questions up on the chat window, and Abby, who's our moderator, will go off and be checking those and interjecting them when they show up. So the background on this bill is that it was introduced very recently. So some bills take a long time to make it through the congressional process, but in this particular case, the bill was introduced in January. There was a lot of behind-the-scenes effort going on, and there were a number of versions of the bill that weren't published, and the governor signed it on May 29th. The interesting thing, and this does not happen very often, is that there was not a single no vote on this bill in either house. The bill goes into effect September 1st, and as I said, this is a part of a trend of increased security nationwide. So one of the things that is a change in this law is typically the way the laws are written, it talks about companies or people that own or license personally identifying information. And notice it doesn't say private or non-public personal identifying information. It says just personal identifying information. It says that anybody that maintains that information is now covered by that law. So if you just go off and create a list, and that list contains personally identifiable information, then you're covered by this law. A person is defined very broadly from an individual through a trust or an unincorporated association, so that it could include things like a homeowners association, for example, and trust and estates. So anybody pretty much is covered. There are
those of you who are familiar with HIPAA or with GDPR, the maintenance requirement accords much more closely with the processing definition in GDPR. So here is an instance where we see some convergence between U.S. law and the privacy scheme that is being implemented through GDPR. Go ahead, Mitch.
Thanks, Dan. In the Colorado law, there is no exemption for size or type of organization. So if you're a one-person organization or you're a 100,000-person multinational, the requirements are just the same. And in one particular aspect, it preempts the HIPAA and GLBA requirements that are put on for healthcare providers and financial service organizations. And the bill has a partnership bill that says that local government agencies are also, and state agencies are also covered by this regulation. So even state and local agencies are required to be compliant with this.
The most significant aspect of the preemption of HIPAA and GLBA is in the mandatory shorter reporting time frames, and Mitch and I will get into that later in the presentation in more detail, but for those of you who are on the call who are HIPAA regulated or GLB regulated, so healthcare or finance, you need to be mindful of the fact that the 60-day time frame under HIPAA, as an example, is no longer the only time frame you're operating under, and you may very well be operating under a shorter Colorado law time frame.
And of course, that doesn't relieve you of any of the obligations to report under HIPAA or under GLBA. This is just an additional reporting obligation. So personally identifiable information is a pretty broad definition. And at the end of the presentation, I'll just touch on the new California law, which probably has the broadest definition of personally identifiable information in the country. But this one is pretty broad. So here's a list. I'm not going to read it, but here's a list of the various kinds of information that's considered personally identifiable. And most of it seems reasonable, like ID numbers of different kinds and passwords or passcodes. But it's a pretty broad definition. So if you collect any of this kind of information, then again you're covered by this regulation.
I think one thing to note here is the addition of passwords and passcodes, which is a trend that we're seeing. And passwords or passcodes includes username or email address plus either the password or the security questions and answers that we're all familiar with that would allow one to reset a password. This is somewhat different than what people would normally think of as personally identifying information. My login and password may not fall within a common definition of that, but there's some key elements of this bill that relate to breaches, security of, and breaches regarding basically online login information, and those bear particular mention because they are new and it's part of a trend we're seeing across the country to add security requirements and notification requirements regarding that type of information.
So the meat of the regulation, and unfortunately it is pretty vague. It says that if you maintain personally identifiable information, you must have a reasonable security procedures and practices. Now there is a little caveat here, so that's good, that says that those practices can be appropriate to the nature of the personally identifiable information and the nature and size of the business and its operations. So if you're the corner coffee shop, you should have a different set of reasonable security procedures and practices than if you are a defense contractor. But I think the big issue there is you've got to be able to defend the definition of reasonable.
I have a question from the webinar, if you're ready.
Yep.
This might be the previous slide, but the question is, what is a financial transaction device?
So a financial transaction device is typically a device which you might get from your bank that generates one-time passwords, sometimes called a fob, and it's used as part of a multi-factor or two-factor authentication system.
Financial transaction devices also include credit cards, debit cards, all of the various items which you might use to access your financial accounts. So it's sort of an omnibus term to encompass all of the different types of. We don't always think of them as devices in the physical sense, but devices that means by which we can add to, extract money from, transfer money within the financial system. So credit cards, debit cards, those type of things.
Thanks, Dan. So the going back to this definition of reasonable security, we're not going to really have any good handle on what's reasonable until the courts start making some cases, and that's probably going to be years. Our recommendation is to use best practices, and best practices are pretty well defined, and we'll talk about those later on in the presentation. Hopefully the Attorney General will define some standards like the Attorney General in California did 2 or 3 years ago, but right now, at this point, we don't have a definition of reasonable, but it's going to be one of those things where the courts are going to go say, well, I know reasonable when I see it.
We do see the law starting to coalesce around some reasonable security standards. If you look at, for example, Massachusetts' data security legislation, if you look at the New York's recent financial services regulation, all of these have some core elements, and I will be covering those later in more detail. It's highly likely that as courts start to define what's reasonable security, there's going to be a fair amount of reference to these laws, which contain some common core principles, and that's going to form a fairly reasonable set of guidelines. And I know, Mitch, you're going to touch on a number of those later in the presentation.
Right. So,
Dan, I have a question on the webinar. I'm sorry.
Go ahead.
Sure.
The question is, The question is, does the law only apply to consumer data, or does it also apply to employee data managed internally?
It would apply, absolutely would apply to employee data. The definition of personal information is not limited to consumer information. It's limited to any information that falls within the elements that were on the previous slide. So if for whatever reason you were holding, for example, biometric information, or for whatever reason you were handling financial transaction information, which includes credit card numbers and things like that, or you have Social Security numbers, regardless of whether it's employees, whether it's customers, whether it's potential customers, whether, for example, if you're an educational institution and these are applicants for admission to your university, that would be another example. It really focuses not on the status of the individual. It focuses on the type of information about that individual that you have.
Right, and obviously this also applies to candidates for employment, as well as current active employees and previous employees. And for example, every employer completes an I-9, hopefully, on every employee, and as part of that, they often will capture ID card information. That's information on the ID cards would be considered personally identifiable information.
Likewise, information on beneficiaries. We see a lot of companies, if you have employees, and a lot of times you'll have beneficiary information. That's sometimes a forgotten repository of names, Social Security numbers, some sensitive information.
One of the other requirements of this bill requires that you ensure that third parties, such as vendors and cloud service providers, protect personally identifiable information before you share it with them. So that means that you need to have a good list of places where your data lives. One of the things we recommend people do is create a vendor data inventory and maintain that, and we do that a lot with our clients, and the list is amazingly large. We have one client working with right now that is a small company of about 400 employees, and the list of people that they're sharing data with is over 400. So this list can get very large depending on your business. Now, alternatively, the law says that you can assume the liability for their bad security habits. I don't particularly recommend that people do that, but you certainly can do that. And if in the absence of you having some kind of written agreement with a third-party service provider that you're using, then you are de facto assuming that liability on behalf of them.
And I certainly wouldn't recommend that you do that. The law either says you have to extend your protections for this data to your third-party service providers. That would be things such as encryption, as just an example, but certainly not the only control that you would need to extend or could consider extending. Or you have to require that the third party implement and maintain reasonable security practices that apply to the information. And the use of the word maintain suggests that there may be something beyond simply a contractual provision. There may be some due diligence that's required with respect to your vendors in order to comply with this law.
Remember that even if the law didn't require this, the good business practice says you're going to do this. You want to have a vendor cyber risk management program in place, because if a vendor gets breached, you're the one who's going to go off and get the bad PR. You're the one who's going to have to go convince your customers not to leave, or in a worst-case scenario, convince your customers not to sue you. So you want to have a vendor cyber risk management, and this is more extensive than your typical vendor management program. Vendor management typically worries about things like licensing and insurance and stuff like that. This is a whole separate program where you're looking at the cybersecurity practices of your vendors, and we're seeing that if you think back to some of the big breaches we've had in the last couple of years, like Target and Home Depot, for example, both of those were caused by vendors not having good security practices. So both of those companies have spent literally hundreds of millions of dollars trying to recover from the actions of a vendor. So even if the law didn't require that, that's still something you want to go have. The law also, interestingly, very specifically, and this is the only proscriptive thing in the law, says that you have to have a process in place for securely disposing of documents. And I think that's come from the large number of incidents that have been picked up by the media locally, where they find boxes of documents in dumpsters or next to dumpsters, and which obviously have not been securely disposed of. So the law has a specific provision that you have to have a written policy for secure document disposal, and that you must implement that. So this is the part where we carve out an exemption for HIPAA and GLBA, and they don't do this in a way that says HIPAA and GLBA don't apply. They just say that we have a stronger requirement, and you still have to comply with all of the requirements that you have for HIPAA and GLBA. So the requirement is that you must notify those people affected by a breach within 30 days. This is the shortest time period in the country. There are no extensions allowed. So that means that you really have to have your incident response program, which we'll talk about later, really well in hand in order to be able to go off and identify those people who are affected. And for example, those people who are affected, may be in Colorado. They may be someplace else. But we're worried mostly about Colorado residents here, and you have to understand, what data was compromised as a result of breach. And the alternative would be to assume that all of your data was compromised, and that's clearly not a very attractive solution. So if you're covered by HIPAA and GLBA, where you have longer notification requirements, you still have to notify those people within 30 days. And the only places where we see shorter notification periods are for DoD contractors and GDPR, both of which have a 72-hour notification period.
This notification period, when you unpack it, contains a number of subsidiary requirements that you have to be careful about. First off, in order to determine whether a breach has occurred, you obviously ought to conduct an investigation. In fact, the statute requires that you undertake an investigation when you become aware that a security breach may have occurred. So hiding one's head in the sand and ignoring the warning signals is in and of itself a violation of the statute. An investigation has to occur. Then you must notify within 30 days of determination that breach has occurred. This is oftentimes tricky in breach notification scenarios because you have incomplete information. You have information that, for example, documents unauthorized access to a system, but you're not sure whether or not that unauthorized access, or it's difficult to tell forensically whether or not that unauthorized access actually led to access to or acquisition of particular data or particular parts of your network. The statute actually puts forward a definition that says what is the determination of a breach. So when does that 30-day clock start running after you begin your investigation? And it's the point in time where there is sufficient evidence to conclude that a security breach has occurred. That is an objective standard in our view, which means that if an objective observer would say there's sufficient evidence here to conclude that a breach has occurred, not overwhelming evidence, not every scintilla of evidence points that way, sufficient evidence, then you are on the 30-day clock from that point forward. This also emphasizes the importance of documentation in the process, which then ties back again to Mitch's point about having a good incident response plan that facilitates that documentation. You're absolutely going to want to have documentation that documents your date of awareness. You're going to want to have documentation that documents the investigation that you conducted, the decisions that were made in that investigation and why, and documentation either way, whether you determine there was a breach or if you determine that there was not a breach. You're going to want to have and retain documentation as to the factors considered, the facts uncovered, and the reasons for that determination either way. We expect that, as we've seen in many states, there's going to be an uptick in investigatory activity to enforce the law, and your best defense, particularly when 6 months, 9 months, a year after the fact, somebody comes with a civil investigative demand or a subpoena or a request for more information, that documentation of what you did, why you did it, and when you did it is going to be key to defending the company's decisions.
And I'm going to do a shameless plug for Dan here. One of the things that's important in terms of your incident response team is to have outside counsel as part of that team, because you want to try to, as much as you can, this is not perfect, but you want to be able to protect information under attorney-client work product privilege, and your outside counsel is the one who's going to be able to help you maximize your ability to go do that. So that's he would be a critical part of your incident response team. The law also says that if the breach affects more than 500 people, you have to notify the Attorney General. And if the breach affects more than 1,000 people, you must notify the 3 major credit reporting agencies. So that's an additional requirement that you have in terms of the notification process. What you don't want to be doing is when a breach occurs, gee, we're going to figure out who do we report this to, how do we report it, is there a standard way to do that? You want to have that all in place, and that's all part of your incident response program. The Colorado law, like a lot of the laws around the country, has some very specific requirements in terms of what must be contained inside the breach notification letter. And that includes things like the approximate date, a brief description, information for how people can contact you. One of these things, then, if this is a large breach, do you need to set up a call center of some sort, because you may be getting a large number of calls, and you probably don't want your switchboard answering that, and you probably don't want your switchboard giving the wrong information. If you do set up some sort of call center, either an outsourced call center or an internal call center, you want to have the responses very well scripted, and you want to have the people who are in the call center trained, because the people who are calling in are probably not going to be really happy with you. The law also requires that you provide the phone number and address for the 3 credit reporting agencies, the phone number, address, and the website of the Federal Trade Commission. And there are additional requirements if this breach was of an online system, like a Facebook or an email system or whatever, where you have to give them other information, like specifically telling them that they should change their password and other requirements.
I have a question again on the webinar.
Sure.
Does this law apply to a business that just does business in Colorado but does not have a physical presence in the state, like an online business?
Great question.
The application of this law and of most of these data breach laws, and this is one of the things that makes breach response tougher and trickier, is that they are designed to protect the residents of the state. So, in fact, it's unfortunate, it's very rare that you have a breach where you're not dealing with multiple states' law. So if you are whether or not you're a Colorado business, if the information touches, if you have the information of one or more Colorado residents that is part of the breach, then you are affected by this law on the notification side. Obviously, the security requirements side is broader in the sense that if you're in Colorado, you better be complying with the security plan part of this as well. But from a breach perspective, even if you are out of state, if you have a Colorado residence information, then this notice provision applies, as well as, I would argue, the security provisions. I want to talk about a couple of things that Mitch mentioned. First of all, very briefly on the call center. Depending on the size of your breach, you may choose to engage a third party to provide call center services. A lot of the same companies that provide the identity theft monitoring, which we all see is pretty standard now. They also provide call center services. It is possible to set up an internal call center with one or more of your employees, We do that sometimes with smaller breaches, but Mitch is absolutely correct. In that instance, there needs to be some training, usually some talking points or FAQs or something provided, an escalation means. So there is some art to setting up a call center. It can be done internally or externally. One other comment I would make is on the additional requirements for online account breaches. An interesting feature of this law, it's not the only state that is doing it, but it's one of the trendsetters, is that in the event that the breach compromises password and login information of, so, just take an example, XYZ company, we'll say Amazon, not that Amazon's insecure in any way, but if Amazon were to suffer a breach under this law, which included people's Amazon logins and passwords, or usernames and the security questions, what we talked about previously, then the notice has to go out expeditiously, and it has to tell individuals that they need to change those passwords, security questions, and they also need to change any of their passwords and security questions on any other website where they were using the same login information. And that's to address the phenomena, the mistake a lot of us make where we use the same password and username combination or the same security questions and answers on multiple websites. And so the notice is not only change your login information for our site, the company that was breached site, but if you use that same information anywhere else, the letter has to say you must also change that information, or you should also consider changing that information if you've used the same username and password combination on any other sites.
And while the Colorado law doesn't specifically address this issue I'm about to say, it is important to understand that let's assume that your own company's website got breached and there is personally identifiable information like a user ID and password and other information that you collect. The people who are affected may reside in many different states. So you may have an overall reporting requirement of a lot of organizations. For example, in New York State, alone you're required to report to 4 different entities depending on who you're regulated by in New York State, including the state police, the attorney general, the head of the Department of Financial Services if you're a financial service organization. So you may have a large number of organizations that you're required to report this breach to, and you don't want to try to do that at the time of the breach, especially given every one of these regulators has a different timeline for how quickly you must report.
We consider ourselves lucky if we're handling a breach and we're dealing with less than, say, half a dozen states where we have to comply with the law and also comply with the regulator notice requirements. It's not uncommon to have breaches where you are dealing with anywhere 15 to 30 different state laws, many of which are similar, but there are nuances, and where you end up reporting in different formats and on different time frames to 10 or 15 different state regulators. And as Mitch said, in some states, you actually have to report to multiple regulators.
And many of these regulators have a particular form on which you must do this reporting. So just sending them a letter in some cases is not adequate. You have to fill out their form.
Yep.
Now there is an exception, and I'll tell you it's a pretty limited exception, and I'll explain why, which is there is no duty to notify if the data is encrypted and the likelihood of anybody being able to go off and decrypt the data is low. But the second part of that is that only works if the encryption mechanism wasn't stolen too. And so, for example, if you had data encrypted on your laptop and your laptop was compromised, but they were acting, they being the hackers, were acting as an authorized user, namely you, the system would very conveniently decrypt the data for the hacker. And so, therefore, just because the laptop was encrypted, it wouldn't give you an exemption. Now, where it would give you an exemption is if the laptop was powered off and stolen out of your car and it was encrypted, then the encryption key is not present because the encryption key gets wiped when the computer gets powered off. But a lot of times people think, and we saw this, for example, in the Blue Cross fiasco several years ago, where some of that data was encrypted, but unfortunately, because of the mechanism by which the attackers breached the system, they had access to the encryption keys, and the system very conveniently decrypted the data for them.
The standard in key security is actually an incredibly good idea, and the statute here is cutting edge in the sense that it specifically calls out the security of the encryption keys. Older statutes, sort of the first generation of these data breach statutes, only addressed encryption, and they didn't bother to say, oh, by the way, if the key is compromised, then the encryption doesn't count. The standard for determining whether or not the encryption keys have been compromised is if the keys have been acquired, so if you have evidence that demonstrates the keys have actually been compromised, or if there's a reasonable belief that they have been acquired. So you have to be very careful about relying on the encryption exception if there is evidence that suggests an objective person would reasonably believe that the keys have been acquired, not just if the keys have actually been acquired and it's a 100% certain fact. So the encryption exception, as Mitch mentioned, is narrower than it might seem at first blush.
Now, one of the things to consider about this law is if you are acquiring a company, or if you are selling a company, or if you are investing in a company, then this law affects you because it affects your interest in the company. So, many times if you acquire a company, sometimes you just acquire the assets, but most of the time you acquire the whole company. Then you are acquiring a liability. The Yahoo Verizon acquisition is a perfect example of this. In that particular case, they discovered the breach, or the breach became public, prior to the closing of the deal, and the result of that was the shareholders of Yahoo took a $350 million haircut, and so that's not a really great thing. Now, if that had happened afterwards, and it could be, there's no tail on this, so unfortunately, sometimes we see that a breach isn't uncovered for a year or more after it happens. So if you acquire the company in that time, then you're acquiring this liability if you're not doing cyber due diligence. On the other hand, if you're selling a company, are you disclosing this liability? And that's also where Yahoo got in trouble, because clearly they knew about this and they didn't disclose it to Verizon, and so you've got a definite potential legal issue there. And in general, if you're just investing in a company, whether it's an angel round in a startup or something more mature, your investment can be at risk. So there's recommendations that we make on all sides of this equation, that just like you do financial due diligence on a company, that you do cyber due diligence. And if you are selling, you want to do that cyber due diligence way in advance so that you have the ability to go clean that up, because clearly if you do cyber due diligence, you can't hide that from an acquirer. So, important considerations if you're making a financial investment one way or the other in a company.
It's been said that, and I think it is true, that today all companies are information companies, and that can be personal data you hold, that can be information that runs your equipment, that can be almost anything. But you're seeing more and more of this, and I think you're seeing more and more smart sellers, smart buyers, and smart investors who are realizing that the liabilities and the potential impacts on the business from cyber-related issues can be really a core concern in almost any business, and frankly one that a lot of times reps and warranties and retained baskets and such are not going to adequately cover for. And so in our view, cyber due diligence, if it's not an absolute requirement, is fast becoming an absolute requirement in almost any investment, buy, sell, invest that's of any scale whatsoever.
So in terms of what the consequences could be here, there's two ways, and this law does not provide for a private right of action, which is good, I guess, if you're breached. But the Attorney General can bring an action both to ensure compliance and to recover damages. And also, at the request of a local district attorney who is a political animal who will likely try to score brownie points, the governor or the DA can request the Attorney General to bring criminal charges. So this is both a civil and potentially criminal matter.
Deanne and Mitch, I have a question on the webinar.
Okay.
Yes.
Question is there any guidance or any forthcoming to determine when PII is no longer needed for purposes of the affirmative destruction requirement? Is it a subjective evaluation depending on your business purposes for that information?
It is subjective in the sense that each company should, as part of their written disposal process, do an assessment of information. This is specifically required for anybody on the phone who is a GDPR regulated, and the GDPR, just in case anybody hasn't heard about that yet, is the European privacy regulation that went into effect on May 25th. So as part of your written disposal plan, it should not just simply be how are we going to dispose of things, but what are we going to dispose of, and why are we disposing of it at this time. So it requires, or it should require, an assessment, and I would strongly suggest an assessment that is done in writing at the end of the day, that says this is what we have, and this is why we need to retain it for this length of time, and after that length of time it will be disposed of, so that there is a documented analysis and thought process that goes into why information is being retained. We have left the age where retain it because it might be useful someday, or retain it because we might someday figure out some new use for it is a justification. You're seeing more and more privacy laws, more and more data security laws, and frankly more and more best practices that simply say you retain information for the period which is of legitimate use for the reasons that you initially acquired the information, or for any other subsequent reason you've given notice to the data subject of. And the days of just simply let's just keep it because someday it might be useful, or someday we might need it, that's no longer a good justification either in law or in practice.
And ultimately that should fit into your written, emphasized written, document retention program, which the company should have, which should talk about all the different kinds of data. Because what you don't want is individuals to go off and decide, hey, I'll keep this data a little bit longer, a little bit shorter, and whether that's email or whether that's employee records or whether that's business records or whether it's financial records, there's sometimes regulatory requirements, legal requirements, compliance requirements that say you have to keep it this long, but that should all be documented so there isn't any confusion on the part of employees with regard to how long a particular category of document should be retained and how the disposal is affected, and that includes both paper documents and electronic documents. So in our last...
Marketing department, we are talking to you.
So in the last 15 minutes, we're going to talk about recommended actions, and that's something which could take a couple hours all by itself, but at least we'll get a start on this. So the first thing is that you should create and implement a written information security program, or WISP. They go by different names depending on what the regulation is called. And many organizations already have to do this. Healthcare, financial, defense, all have to do this already. But basically, this is the overarching document which describes your information system programs, practices, policies at a fairly high level, responsibilities, and this should be something which is reviewed and signed by executive management. If you have a board, this should be part of the board's due diligence to go off and oversee and make sure that this program is actually being followed. second part of that is to designate a person who is responsible for managing the information security program. It's sort of, one throat to choke. Who do I go to if there's a problem? Obviously, in the case of a breach, that person is going to run and hide. But on the other side, from the corporate standpoint, there should be somebody that executive management can go to and say, okay, let's talk about what we're doing. How are we protecting this? We read the news or we listen to the news, and we want to make sure. And somebody is going to have to go implement that written information security program. Conducting a risk assessment at least once a year, again, for those organizations that are regulated, they're already doing this, or at least should be doing this. But organizations that are not regulated, it really doesn't exempt you from the fact that this is a reasonable business practice given the state of the universe today of cybersecurity. We see organizations that get breached on a regular basis. We just saw one, for example, at LabCorp, the big medical lab testing organization. They were hit with a ransomware attack, and they very, very rapidly responded to it. I mean, it's kind of a case study of some good things. I wrote in my blog last night about that. They did some things right, and it's a good benchmark to go off and compare yourself to. But a outside, independent, third-party risk assessment at least once a year.
And I want to emphasize on risk assessment because there's some confusion in terminology. If your company's IT group is commissioning and doing a quote-unquote risk assessment, close quote, you're probably not actually conducting a risk assessment in terms of an overall information security plan.
Thank you.
Both Mitch and I have worked with many IT departments. They're great. But when they think risk assessment, they think hiring a vendor to come in and scan their machines to see if they've got all the correct patches and if they've got flaws in the actual network. That's not a risk assessment, at least not in the way that the overall security principles discuss. A true risk assessment involves other parts of the organization. It's an overall look at what data you have, what obligations you have under the law, under contracts, under other schemes in terms of obligations, and what the potential vulnerabilities and impacts on the organization are. And by that description alone, you can tell this is not something that IT alone is equipped to assess. So if you're not doing a risk assessment that involves the entire organization in the assessment process, and rather it's just something that IT is doing, it's not a risk assessment.
As an example, one of the things that we do when we do risk assessments is we dig into the question of whether or not the company is a HIPAA-covered entity, and we discover many times that companies don't think of themselves as a HIPAA-covered entity, and therefore they're not complying with HIPAA regulations. But, for example, because they are self-insured for their employee health insurance, they are a HIPAA-covered entity, and they have access to HIPAA-covered data, and all of a sudden now, and they don't have any HIPAA controls in place, of course, because they didn't think of themselves as one. So that's just one example of a place where you go in overall risk assessment where people, certainly IT doesn't have any visibility to that. Training is never going to solve all problems, but almost every piece of every cyber breach has a human element. Now, obviously, a lot of breaches have the thing where the user clicks on something and lets the bad stuff in. That's the obvious one, but it's much bigger than that. For example, are you allowed to, in your physical office, are users going to go off and stop people they see wandering the halls because they've been trained? They understand that people are supposed to be, if they're a visitor, with a host, or they're supposed to be wearing a badge, or the badge is supposed to be visible. So training covers a whole raft of things, and what we've seen in a lot of places where after lunch they drag everybody in a conference room and they show them a video and say they can check the box that said, yeah, we trained everybody. That does not work. One of the things that you really need to be doing, and we have a very cost-effective program for doing this, is active and aggressive anti-phishing training, because so much of the stuff these days comes from phishing, either from emails, text messages, and phone calls. We do the phishing over phone calls is called vishing or voice phishing, and we see a fair amount of that. We have a new client that we acquired after they had to write a check for something north of $100,000 because one of their call centers got vished. So that that often gives you religion, but the training is really, really critically important to things. Number 5 is to create a disaster recovery plan. One of the things that you don't want to deal with is, we just had our primary outsourced vendor went down, and now none of our customers can get to their data, and we're basically effectively out of business. You want to create that disaster recovery plan, and it needs to include third parties that are critical components of your system, and you need to test it periodically. And you can test it, a cost-effective way to test it is through tabletop exercises, but the best way to test it, obviously, is going to be a real-life test, and it's really how active and aggressive you are in this is really a function of how important online systems are. A perfect example, and one people don't think about, is when your cash register goes down. If you have a retail store and your cash register stops working, then what do? You literally can't take care of customers. So here you say, I'm not a high-tech business, I'm a coffee shop. Well, yeah, you're a coffee shop, but you want to be able to take customers' money. You want to be able to go off and process their credit cards. And if your cash register, now fancy term for cash register point-of-sale system, doesn't work, then you can't do that, and you literally have to shut the doors or give away your product for free. So critical.
I want to emphasize what is not a disaster recovery plan. Sitting in the office and saying, we do backups, that is not a disaster recovery plan. Unfortunately, we have seen a number of breach incidents where a client has had some sort of an intrusion. Sometimes there's the possibility an intruder may still be within the system. Sometimes it's ransomware where it affects the backups as well. And the net effect is you have a client who is down dark for a week, maybe more than that. And these are instances where on the back end people wish they had had a thoughtful disaster recovery plan, which is beyond simply, oh, we do backups, and that plan had been tested. So at the very least, they knew that they had a risk of the business going down for even 24 hours. These days counts as an extended period of time, and that there had been additional mitigation measures put in place to try to address any weaknesses that would cause extended periods when the company was without its digital assets. So a disaster recovery plan is a lot more than simply, hey, we have a backup.
And we've seen a number of businesses where they get hit by a ransomware attack where the data gets encrypted and the hacker says, we'll give you back the decryption keys if you pay us money. And they say, oh, we got backups, and then they discover it's going to take them weeks and weeks to go off and restore the systems. That's a really bad disaster recovery plan, probably a non-existent one. Next piece is to create an incident response program and a team. That means people who know that they're part of the team, and test this plan at least once a year where everybody gets together, and that includes, for example, we can use one of my favorite punching bags is Equifax. They clearly did not have an incident response program, and their response, where, for example, their so-called crisis communications team sent people to the wrong website to find out about the breach, that the website that they created for the breach wasn't even owned by Equifax because their outside marketing firm stood it up after the breach occurred. So crisis communications, marketing, sales, operations, IT, security, outside security firm, outside legal, inside legal, and there should be a core of that team that's going to get together as soon as there's something which appears to be a potential incident and go off and huddle to figure out, okay, let's go figure out what we need to go do. And that needs to be well practiced and well thought through.
We oftentimes tell clients this, particularly if you're consumer facing. What we see is consumers becoming somewhat more tolerant of the fact that you've been breached. They don't like it, but they've all been through it. Whether it's Target, whether it's Anthem, whether it's any one of the other number of high-profile breaches. The flip side is that your customers have become absolute connoisseurs of what an appropriate breach response looks like, because they've seen other companies do it right. And there's a set of consumer expectations as to how quickly they're going to be notified, what they're going to be told, how smoothly the process should work. So I'm not suggesting that customers like it when you tell them they've been breached, but if the response is handled correctly, then the amount of customer outrage, the amount of business loss that's going to come out of that is going to be substantially less than if you botch the response. A botched response is where you start to see customer anger multiplies exponentially. You start to get the really bad press about the botched response. You've created a whole new problem that may be as significant or more significant than the initial breach, and which can be really damaging to your business. So incident response planning and appropriately executed incident response is critical.
And going back to my favorite punching bag, Equifax, they just got absolutely excoriated on social media, Twitter, and similar platforms because of their handling of the event. So you have a very, very short time window to go off and react. Number 7 is to encrypt all sensitive data, even at rest. Whether or not there's a specific regulatory requirement to force you to do that, you just need to do that. It is just a basic requirement these days, and that includes cell phones, tablets, laptops, as well as stuff in your data center. Access controls, for folks in a regulated industry, they're already familiar with this. Access control says that Joe can have access to certain data based on Joe's role. Joe shouldn't have access to everything just because he works here. And there should be some logic. It should be documented. It should be thought through. And it should, if you have a compliance requirement, should be part of the compliance process so that you make sure that you're meeting all your compliance obligations. Number 9 is, and really number 9 is required in order to do number 8, so maybe we should flip the order of them, but you should have a data classification and document marking program so you know what kinds of data you're keeping, whether it's trade secret or whether it's HIPAA or whether it's financial, whatever it is. You need to have a program, and employees need to understand what those data classifications are and what that means in terms of what they can and can't do with a piece of data. And we just saw recently an NSA developer, you'd think NSA would understand that, who took a certain piece of code home to work on it. And ultimately the Russians got the code and cost us millions of dollars because of that, because apparently he didn't quite get the program. Now, clearly NSA has a program, but training the employees on it as part of the employee training program, training employees on this data classification, data marking, document marking, and that means both paper documents as well as electronic documents. Number 10 is to go implement a security event logging and auditing process that's appropriate to the risk. So if you have been breached, you don't want to find out about it 6 months or 12 months later. You actually want to know. And the only way to do that is to be able to go log the appropriate things, audit those things, and alert based on events that you see that don't make any sense. This is not a simple task, but it's an important task. And then I think number 11, the last one, is to create a third-party cyber risk management program, because everybody uses third parties these days. Obviously, we're already basically at the end of our hour. There's a lot to this bill. Here is a link to the website, or you can just put in Google, Colorado House Bill 1128, and get a link to the bill. There's a lot of stuff there. Obviously, you can also reach out to Dan and myself. very, very quickly, Oregon, as another state, went off and increased the scope of what they define as personally identifiable information. And this has actually changed now. This should be updated. California has passed a law called the California Consumer Privacy Act that is a very, very aggressive consumer privacy law, and that goes into effect on January 1st, 2020. And many other states, as we keep saying, are tightening their laws, so this is a moving target. There are no easy answers to this. As the only plug we'll have here for us, we do have a business cybersecurity certification program. You can just Google business cybersecurity certification program. It's a fixed price program for many businesses other than large businesses, multi-location businesses. But 95% of the businesses will get what they need to comply, and so you can go do that. And obviously, reach out to Dan or myself if you have questions. I mentioned my blog earlier. If you go to cybersecurity.com/cyblog, it'll take you there, and you can register and get a copy of all the posts that I make there. This is one of those places where you really need to become educated. So.
And that blog is one of my absolute go-to sources. I get Mitch's newsletter every Sunday night, and I read it with great interest.
I think we're about out of time, Abby, unless we have any more questions. I think we're going to wrap it up, but just reach out to one of us, and we'll be happy to go answer any other questions.
For right now, we don't have any webinar questions, but if any come through, I'll make sure to follow up with you guys. Thank you very much.
Thank you, everybody. Thank you for your time today. We know you're busy and have lots of competing demands on your time. Cybersecurity is an important aspect, and we appreciate your being here.
Thank you so much.